All right, well, thank you, everybody. Welcome to our podcast, How to Overturn an Environmental Agency Decision. It will be presented today by Jim Lang with the Waterfront Law Team. Before we get started, we always have just a few housekeeping items we like to review. Namely, if you could kindly make sure your cameras are on mute during the duration of our webinar. We have saved time at the end for Q&A. So if something pops to mind, feel free to drop it in the chat, or we will get to it at the end at the conclusion of our webinar. And lastly, we'll be recording this webinar. So this will be available post-webinar for review and to watch again, as well as our slides that Jim will share during the presentation. And with that, I just want to introduce Jim very quickly. He's shareholder and former COO of the law firm Pender & Coward. Jim focuses his practice on protecting Virginians who live, work, and play on the water. The Waterfront Property Law Group at Pender & Coward was established by Jim. He and the three other attorneys in this group routinely handle all aspects of riparian property rights law, maritime and admiralty law, and environmental law. And with that, I'll hand it over to Jim.
Yeah, well, good morning, everybody, and thank you for coming to our webinar today. Let me put up a slide that tells you what we're going to cover over the course of the 15 or 20 minutes that we're going to spend together. We'll give you an outline of situations where judicial review might be important to you. We'll cover what a courtroom win would look like for you. And we'll also work through the steps that you've got to work through in order to get your case into court. And then cases of this type are very different from your typical civil case, and we'll touch on some of those differences. We'll talk about cost of prosecuting a case like this, and then the things you can do to increase your chances of winning if you decide to take a case to court. So oftentimes we have somebody who is interested in going to court because they don't like the fact that the agency issued the permit in the first place. And I've given you an example of that up in the first bullet point. Somebody has a beautiful piece of waterfront property, and an oyster company has submitted application to install floating oyster cages, which sit up on the surface of the water. They're unsightly. They get in the way of your effort to boat or otherwise use the water, fishing and the like, swimming, paddle boarding. If a lot of floats in the water, they're going to interfere with that. And so they want to go to court to get the court to overturn the issuance of the permit because they don't want those floating oyster cages going into the water in front of their property. And it's not only interfering with their recreational amenities and their navigational rights, but also that can negatively affect the property value if you've got a beautiful waterfront home. So that would be one example. Another example, kind of looking at it from a little bit different perspective and a different agency. We had a case a year or two ago where a neighborhood in Virginia Beach was having serious flooding. It was impacting 250 homes. The water was coming into the houses. It was sometimes up to 12 to 18 inches high inside the house. And it was happening repetitively, and it was happening to enough people that there was a lot of attention and focus on coming up with a solution. Part of the solution was going to require filling some wetlands. And so the people who were going to fix the problem got the necessary permit from the Army Corps of Engineers to fill those wetlands. And then an outside group, an environmental group, a nonprofit, brought suit in federal court to try and undo the issuance of that permit. And if they had, well, certainly during the time the court case was pending, it was placing on hold the construction that was needed to fix the flooding problem. And if the case succeeded ultimately, it could have derailed the entire project entirely. So this is an example where we came in on the side that was arguing to the court that the permit should be upheld. And this was in federal court. So the first example I gave you, the VMRC, that's a state agency, a state regulatory agency. The second example I gave you is a federal regulatory agency. And I've given you a couple of other examples where somebody might be unhappy with the decision of the agency and they might want court review. But rather than dive into those, let's get into how the cases work. So if take the situation of the waterfront property owner who objected to the aquaculture being installed in the water in front of his house. The state agencies have issued the permit, and the floating cages are going to be installed unless he can go to court and put a stop to it. If he does go to court and he wins, I think it's important to know what it means to win in court. The thing that's important to remember is that the court is not going to order that the permit be disapproved. That's for the agency to decide whether the permit should be granted or denied. But what the court will do is reverse the agency decision, point out what the errors were that the agency made while the application was in front of the agency, and then tell the agency to do it over again. So you can go to court and you can win, but then the application is going to go back to the agency and the agency is going to issue a fresh decision. And it's entirely possible that the agency would approve the permit again, meaning that this person would be looking at going back to court yet again as a possible outcome. But you're not going to have a court decide whether the permit should be approved or denied. That's for the agency to do. What a courtroom win does is sends it back to the agency for the agency to do it over again. Getting your case into court. There are lots of very important steps you have to follow, and the agencies, both state and federal, are very good at pointing out to the court any steps that were skipped. And oftentimes missing one or more of these steps means that your appeal into the court or your court case is going to be dismissed without the court ever getting to the merits. So it's very important that you've identified the correct court. It's very important that if you have the right papers at the proper places. One example being in the appeal of a state agency's decision, you may have to file a notice of appeal with the state agency, and oftentimes there will be a deadline associated with that, might be as short as 30 days. And if you don't file the notice of appeal, or you file it on the 31st day, or you file it timely but in the wrong place, your appeal is over. And once the 30 days has run, then you no longer have a right to take it into court. For both federal and state, it's important that the right person sues, and that's called standing. And the parties that will have standing are those that can prove that they are injured by the decision and that the agency decision is the direct cause of the injury, and that the remedy they're looking for from the court will redress the injury. And there oftentimes in these kinds of cases is very early in the case, there's going to be motions practice over standing, because the agencies know that if they can show to the court you don't have standing, the case is over, and they never had to get to the merits of the case. On the federal side, a lot of the federal agencies, the U.S. Army Corps of Engineers, for example, they provide for an appeal within the agency after the agency issues its decision. And the doctrine of exhausting administrative remedies is what comes into play here, because Again, specific to the Army Corps of Engineers, but it's also true with other federal agencies. If they provide an agency appeal right and you don't avail yourself of that and try to go straight to court, your case is going to be vulnerable or in jeopardy to a motion to dismiss for failure to exhaust administrative remedies. And lastly, there could be a filing fee, but there's a lot of very technical, very specific requirements that you have to satisfy in order to get a court to reach the merits of your claim that the agency made the wrong decision. The standard of review. Now, we've talked so far about state agencies making decisions and federal agencies making decisions. And what I have for you here is the standard of review if you're dealing with a state agency decision. And if you're telling the court that the state agency was wrong because they misconstrued the facts, it's going to be a real uphill battle because the court is going to defer to the administrative agency's fact finding. And practically what that means is, let's say that the agency, within the context of the homeowner who didn't want the oyster cages installed in front of their home, let's say that the agency found that there wouldn't be any realistic interference with navigation. They looked at the distance from the person's home to the cages. They looked at the manner in which navigation happens in that area, what sort of vessels, where do they go, what are their traditional paths. And you want to take the position that they got that wrong, that they overlooked the types of vessels that come into the waterway, or they misconstrued the paths that the vessels will follow. Those sorts of factual findings, the court is going to defer to the agency. And so long as there is almost any evidence in the record that supports the agency's point of view, the court is going to go with the agency's determination on that factual point. And this is true even if in the record there's a whole bunch of evidence that supports your point of view and only a little bit of evidence that supports the agency's point of view. The court is still on a factual finding from the agency. The court is going to go with the agency. So factual findings are very difficult to get overturned on appeal. Now, if the agency made a procedural error, like for example, it didn't properly notice some of its proceedings, or it made errors of law, like it misinterpreted a statute, those kinds of issues, you're going to get a lot more leniency from the court on those kinds of issues than you will on factual issues. But factual issues, it's a very difficult standard that you're up against if you're appealing an agency's factual finding. Now, on the federal side, think of the Army Corps of Engineers example I gave you a minute ago. There you're dealing with the Administrative Procedure Act, and I've given you the code citation for that. Whereas on the state side, you're generally dealing with the State's Administrative Process Act. And I had the citation to that statute on the last slide. But the standard of review is very much the same in federal court as in state court. That is, deference to factual findings made by the agency, no deference on procedural errors or legal findings by the administrative agency. And a footnote as to procedural errors, even if you found procedural errors and there's no deference, the court gives no deference to the agency on those, you're still dealing with the harmless error doctrine, where the court says, okay, the agency did make a procedural error, but it was minor and harmless, and so we're not going to grant relief. Again, these are the kind of things that can make it difficult to take these cases into court and win them. So these kinds of cases, when you're getting a court to look at a federal or a state agency's decision and asking the court to overturn it, they're very different from the kind of court case that you might be familiar with if you've ever been involved in civil litigation, or even seen courtroom stories in the movies or on television, where witnesses take the stand and documents and photos are introduced into evidence and a jury decides the facts. These cases are very different. Why is that? Well, the reason for that is because of the doctrine of sovereign immunity. And that goes way back in our traditions and history, all the way back to kings in England and the like, who were immune from being sued by anybody. You couldn't sue them at all. It was sovereign immunity. They were immune. And in our country, it originally was that you couldn't sue the government, but our legislatures passed statutes that waived sovereign immunity. And in waiving sovereign immunity, our legislatures got to decide how those lawsuits would be structured, given that they were conferring an ability to sue the government where none existed before. They could put conditions on it. And these are some of the conditions that I've listed for you here on this page. You are not going to get a jury when you take one of these cases into court. It's going to be decided by the judge and the judge only. You're also not going to have the ability to introduce documents or put witnesses on the stand because the administrative record is the body of evidence the court's going to look at. Let's take a minute and talk about the administrative record. That is a compilation of all of the documents that were in front of the agency at the time the agency made its decision. So internal memos going back and forth, papers, letters, arguments, briefs submitted by people who have a point of view about whether that permit should be issued or not. That all goes in the administrative record. For example, the Army Corps of Engineers wetlands case that I mentioned to you in our second or third slide, where an outside environmental nonprofit group sued in federal court to overturn the wetlands permit that was needed for the system that was going to stop the flooding in that neighborhood. Well, that nonprofit environmental group was sending its point of view in the form of letters, sending it in to the Army Corps of Engineers while the permit was in front of, or the application was in front of the Army Corps for decision. And so all of those materials submitted by that group were part of the administrative record. But that administrative record closes when the agency makes its decision. And so if you have really good points that you want to make, you better get them into the administrative agency before they make their decision. Else those points won't be in the administrative record. And if they're not in the administrative record, you're not going to have the material you need to make your arguments in court. The next point here about the standard of review. In a normal civil case, the burden of proof is preponderance of the evidence. Is it more probable than not? People think of it as the 51% standard. Or in a criminal case, it's beyond a reasonable doubt. But for these kinds of cases, with respect to the facts that the agency decided when it was reaching its decision on the permit, with respect to the facts, you've got to think in the opposite direction. It's a very low standard of review. It's the arbitrary and capricious standard. And that is, the agency's decision on a factual matter will only be overturned if there was no substantial evidence in the record and necessarily nobody could have come to the decision the agency came to It has to be arbitrary and capricious. And that's a very low standard for the agency to defend against on a factual matter. So far, the things I've shared with you suggest that it might be harder to win in court against an agency as compared to a normal civil case. But this fourth bullet point on this slide offers you some encouragement. You might recover some of your legal fees if you win, where in a normal civil case, everybody pays their own legal fees. So that is an unusual and very positive feature. You could get some of your legal fees back if you win your case against the agency. How much does it cost to do this? Well, the cost really does vary. I've given you a wide range here of $25,000 to $125,000. And it's not unlike when you're going to buy a car. You can get the base model and there's a price for that, or you might want some other features in your car. You might want leather seats instead of the other option. You might want the upgraded sound system. All those things add to the price of your car. Well, the same thing happens here. You get your case into court, and let's say you think that some things were left out of the administrative record because you remember that you sent in some materials for the agency to consider. And when the agency put together the administrative record and delivered it to the court, they left your stuff out. Well, you're going to have to file a motion to get the court to agree to add those documents or pictures to the administrative record. And prosecuting that motion is going to increase your cost. Or maybe you want in the aquaculture example that I gave you, maybe while your case is pending in court, you want the applicant to be prevented from installing any of they've got their permit, you want them to be prevented from installing any of their aquaculture until your appeal is decided. Well, that's going to take a motion, and that's going to add to your expense. There's other things that could happen that would add to the expense. Maybe you get your case into court, and the first thing that happens is the agency files a motion to dismiss because they say you don't have standing. Well, you're going to have to defend that motion, and that's going to add to your cost. So there's a wide range of variables here. Are you in state court? Are you in federal court? But your costs can vary widely for these kinds of cases. Things you can do to increase your chance of winning. I think of this a little bit like the person who has a badly broken leg and they decide to use home remedies instead of going to the hospital and getting it treated. Chances are that person is going to have a limp for the rest of their life. And even if they just delay getting medical treatment, they just wait a month. Well, those bones start healing in a way that's they're not going to like. And it may be that just having waited would put the person in a position where the problem now, which could have been dealt with in a much better way, they've lost some options, and now the problem can be fixed, but not to the extent it could have if you'd come in earlier. And it's the same thing in these kinds of cases. You need to find the right kind of attorney to help you with this, somebody who's well versed in litigation of these kinds of cases. And you need to get your attorney in early. And one of the biggest things that will hurt you if you wait too long and you don't get the things into the agency that you need, that you're going to need in the administrative record when you go to court, and you don't get them in, then you're going to have very little chance of prevailing in court. So the key thing is to find the right attorney and get them involved very early in the case. I'm going to close here with giving you a couple of additional resources. Both of these you'll find on my website, waterfrontpropertylaw.com. One is a blog article that covers some of the points we've talked about today. And then the other is a write-up on the case with the Army Corps of Engineers that I mentioned to you earlier with the neighborhood development that was suffering from so much flooding. And with all of that, I'd be glad to take any questions that any of you have.
Thanks, Jim. If you all would like to drop your question in the chat function, or if you'd like to unmute yourselves, I think there's a small enough crowd here that we could manage that as well.
Yeah, can you hear me okay?
We can.
I was
Good
just
morning.
typing them into the chat. I had a question that maybe has just been covered a little bit, but for permit applications that are being reviewed by Army Corps already, where there's already been a jurisdictional determination about the wetlands prior to Sackett, have you heard anything about how that review process is being altered, or if it is being altered in light of Sackett, i.e. are these like permits that are already in the queue being reviewed in a different way, or is Sackett being interpreted to apply to new applications that come in the future?
Oh, great question, Scott. This reminds me of a question that was put to a professor when I was in law school, actually 3 decades ago. There's a civil procedure class, and the student raised her hand and asked the professor, if we're in the middle of our case and the state Supreme Court issues a decision that's on point and controlling for one of the issues in our case, and that came down yesterday, do we have to follow that today? And the professor grinned and said, yeah, you have to follow it. That's the law. And that's the same thing with the Sackett decision. All of the permit decisions that the Army Corps of Engineers makes must comply with the legal standard that was set in the Sackett decision, notwithstanding that the application might have been submitted to the Army Corps a year ago before Sackett had been decided. So it may be the case that the Army Corps has to rethink some pending applications, or it may be that many of their pending applications aren't affected by Sackett because it's clear there's a connection between the wetland and a water of the United States. But
Sure.
The Army Corps is going to have to comply with Sackett with all of its decisions that come out at any point after the time Sackett was decided, which I think was last maybe April or May when it came down.
Sure. And the onus there is on the Army Corps. I mean, if the Army Corps makes a decision, a developer could, or an applicant could appeal it saying, actually, you're not entitled to regulate this, like these wetlands are no longer regulatable. And so even though I applied for a permit initially, I'm now going to say, I don't need a permit. Like that could be a...
Right. It could. Now, if the applicant wants to appeal what the Army Corps of Engineers decides, now we're dealing with a federal agency now, and the federal agency, the Army Corps, has established administrative appeal rights for applicants. So the applicant will not be able to get the case into court unless first the applicant goes through the administrative appeal rights that are available with the Army Corps. So, they get their decision from the Army Corps, they submit their RFA or their request for an appeal, and then that kicks in the agency appeal process. And then when the agency appeal process has run its course, then the applicant can go to court if that's what the applicant wants to do. Now, if you're not the applicant, you don't have that administrative appeal right. That's just for the applicant. And so a non-applicant just has to wait until the Army Corps has issued its final decision that would include any administrative appeals that were rights that were exercised by the applicant. But once the Army Corps has reached a final decision, another person who can demonstrate standing, and standing was described, on the 4th or 5th slide, 6th slide of my presentation, different elements of standing. But if that non-applicant can demonstrate standing, then that non-applicant can get judicial review of the Army Corps' decision.
Got it. And just building off the previous question about, well, maybe tangentially about property rights, and I can imagine situations in which you mentioned an environmental nonprofit, for instance, in one of your examples, where I feel like the motivation for challenging agency decisions is about wanting to protect wetlands for wetlands' sake, and feeling like you have a strong case. And then there is the question of standing. And so I'm wondering, without making this too specific, like how hard is it if you are, say, like, you live close to the wetlands that are being where somebody has applied to discharge into them and applied for a permit to do so. And, so you want that to not happen because you think wetlands should be protected, but you have to prove standing to get into court. How challenging is it if you just, do you have to prove concrete injury, like that you would be facing some sort of like, well, doing this would change the flow of water or it would cause me financial harm? And, once you've done that, you can move on to the merits? Or do you just have to say, well, I'm going to be affected? How high or, how challenging is it to prove standing in these cases where, maybe your primary reason for going to court is not to like avoid some sort of massive harm, but is really about wanting to protect wetlands? But
really, really good question, Scott. And let me preface my answer by saying this is one of the exceptions to the rule that the court only looks at what is in the administrative record that was compiled by the agency. A person who's going into federal court to challenge a permit issued by the Army Corps of Engineers, in addition to the administrative record being in front of the agency, that person can attach to their complaint that they file with the court an affidavit that is used to demonstrate their injury and the causal connection between the injury and the issuance of the permit, and also how the court, if the court rules for you, how this would redress the injury. So you do get an ability to demonstrate standing external to the administrative record. That's one of the very few exceptions to the rule that the administrative record is the only thing in front of the court. But your question goes to, well, how would that person demonstrate standing? And here I would think about the environmental benefits that a wetland provides. And those typically are along the lines of their wetlands are very helpful for controlling flooding because they soak up excess water. Wetlands are very helpful for preserving water quality because they filter the pollutants that are carried by stormwater that runs across the land and tries to get into the water. Wetlands are wonderful habitat for all of the little critters that need some place to live and are part of the food chain. And if you're not going to have the big fish that a striper fisherman likes to go after. You're not going to have those if there's no little fish for those striper to eat, and a lot of those little fish depend on what happens inside of a wetland. And so that's one way to think about trying to demonstrate injury. If your property would be negatively affected by the issuance of the permit because of some of these reasons I've outlined, or if your recreational use of the water amenity is going to be affected because of the wetlands being filled, you can't fish, for example, or a number of things. Sometimes you have to get pretty creative, and if you get too creative, the court's going to shoot it down. There needs to be a direct line between the permit and the harm that you're going to suffer in your personal life in order to demonstrate standing. Did that answer your question, Scott?
It does, yeah, thank you. I mean, it seems like there's a balancing act between being able to talk about the benefits of wetlands to everyone, and in that sense, to the ecosystem, and therefore to people who live in the watershed, you know, everyone's going to be injured in some sense. And then also tying it back to you specifically, that's, you can get into these broader issues, but there has to be a link.
Yeah, you really put your finger on something. If you have an injury that is felt by the public generally, that oftentimes won't qualify. The courts are looking for a particularized injury that's specific to you. And it
Got it.
has to be borne out by, you know, your lifestyle, the way you live your life.
I
Okay.
had one final question about the car analogy when it comes to the cost of judicial review. And you mentioned that, you know, for instance, if the defendant files a motion to dismiss, you have to litigate that motion. In your experience, how successful are motions for summary judgment filed by the plaintiff? Because I would imagine that that could significantly reduce costs by not, you know, by basically stopping the trial relatively early. Is that something that is happens in these sorts of cases if you have a really strong case, or is that more of a exception?
Really great question again, Scott. Let's break this into two parts. Let's talk about the court review of a federal agency decision, like an Army Corps decision to issue a wetlands permit, and there's any number of other federal agency decisions, but we're just using the Army Corps for example, and wetlands for an example. And then we'll talk about state court. In federal court, these cases, if you get past the potential jurisdictional motions that sometimes pop up at the very beginning of the case, and if you lose them, the case will be dismissed. If you get past those and you get to the merits, the case is going to be decided on summary judgment. And just think about the fact that these cases don't involve witnesses giving testimony or evidence being introduced at trial. It's all the administrative record. So there's no trial for the court to do. All the evidence is in front of the court. And so summary judgment is going to be the vehicle that's going to produce the decision in the case. And that actually, I think, helps hold costs down because, you know, seating a jury takes, you know, half a day to do. And there's an expense that goes with that. You're paying for your lawyers to do that and preparing for jury selection. And then, you know, taking witness testimony, introducing evidence. That's why trials sometimes last several days or even weeks. But that's not going to happen in a case like this. All the evidence is in front of the court in the administrative record, and summary judgment's the vehicle that's going to decide the case in federal court. Now, if you're in state court and you're appealing a state agency decision, typically you're going into the circuit court at that point, not the Virginia Court of Appeals or the Virginia Supreme Court. And you're going to initiate the case differently than you will the federal case. In state court, for the most part, you're going to be filing a notice of appeal with the agency, and then the agency is going to pull together the administrative record, and they're going to send that over to the circuit court. And then you're going to have a timeline by which you have to make follow-on filings, like you have to file a document that tells the court the specific mistakes you think the agency made. And then you're going to have to make a follow-on filing that gives all of your arguments as to why you think you should win, but it's limited to only those issues that you put in your petition for appeal at the beginning, where you identified the issues. And then the state's going to respond with their brief. You're going to get one more brief. Then there will be a hearing and you'll get a decision, which is very summary judgment-like, but it's not called summary judgment in state court. But it in terms of the practical nuts and bolts of how it works, it's pretty much the same. Does that answer your question, Scott?
Absolutely. That's extremely helpful. Thank you.
Any other questions?
Yeah. Excuse me. I was wondering if you could comment on the VMRC is being sued for issuing some Menhaden allocation changes outside of their own regulatory time intervals that they're supposed to. And I was wondering if you're familiar with that case, if you could just sort of comment on it.
George, I'm not familiar with it, but the VMRC, besides issuing permits, which we talked about, the permit for the aquaculture is as an example that we've used during our discussion today. The VMRC also issues rules that provide the allowable catch for all kinds of species. They balance how big the blue crab crop is going to be, and then they decide based on that how many blue crabs can be taken. They do the same thing for Menhaden and all kinds of other species, and those kinds of decisions can be challenged in court. But the challenge is going to be, again, it's going to be the administrative record and the arbitrary and capricious standard, and a judge alone, not a jury. It's going to be decided using the same mechanism that I described earlier in my talk today. But I don't have any specific insights to the challenge to the Menhaden allocation that you brought up.
Yeah, I was just curious about that because it seems like they do have jurisdiction to do that. But, according to a previous, regulation they had, it violates their own regulation here. And it seems an unusual case.
Well, if they did it in a way that violates their own regulation, that could get you out from under the arbitrary and capricious standard of review, where deference is given, the court gives deference to the agency, and instead gets you into that much more favorable category of a procedural error or a legal mistake, a misinterpretation of law, where the court gives no deference to the agency, and it's much more likely to get a win for you if you're in that second territory, as opposed to challenging a fact that was found by the agency. We're close to running out of time, but I think we have time for one more question if there is another one out there. And maybe there isn't another one out there. And so I want to thank all of you for coming to our presentation today. And I hope you have a great weekend. And should you need to follow up with me on anything we've talked about today, my contact information, both phone and email, was on the slides. And as well, my website, www.waterfrontpropertylaw.com, has all of our contact information, in addition to many, many helpful blog articles covering a variety of topics. So thank you for coming today, and I hope you have a good weekend. Thanks, everybody.
Thank you.